Hello everyone. Today we are going to study about the Indian Contract Act 1872, 9 of 1872, which is the ninth act of 1872. So let us have the brief introduction of the Indian Contract Act 1872. This act was enacted in British India on 25th of April 1872. It was the ninth act of 1872. It came into effect from 1st of September 1872. Now, this act is a prospective act and not a retrospective act, which means that it is enforceable for law of contracts, for contracts basically after the 1st of September 1872 and not applicable for any contracts executed prior to 1st of September 1872. Now, the original act had 11 chapters and 266 sections. However, the chapter 7, which was relating to sale of goods, and chapter 11 relating to partnership have been repealed and have been made into different acts, which are the Sale of Goods Act and the Indian Partnership Act. Begin with the preliminary chapter of the Indian Contract Act 1872. We'll start with the section 1, which is the short title. So this act may be called the Indian Contract Act 1872. So this gives us an idea about what we should call this act wherever we are referring it to. Now, the extend is it extends to the whole of India. In earlier statute, it excluded the states of Jammu and Kashmir. However, that has been repealed in the year 2019. And commencement is that it shall come into force on the first day of September 1872. So it is on force from 1st September 1872. The next we come to is the saving clause, which says that this particular act would not affect the provision of any other statute, act, or regulation, any other law which is not hereby expressly repealed, which is not expressly repealed under this act, nor any usage or custom of trade, nor any incident of any contract not inconsistent with the provisions of this act. So, this act uh, basically is trying to codify a lot of uh, system on the contracts. However, if there is a usage or a custom in trade, for example, if I have to give some goods to you and you give me a small note, handwritten note, that the goods are accepted and you'll make the payment on the due date. Now, if it is a custom of the trade and it has been continuing for last 30 years, 50 years, so that would be acceptable under this act if it is not inconsistent with any provisions of this act. So it basically is upholding the existing usages or the business trade practices, if you can say, when it is not inconsistent with the provisions of this act. So this is a very important clause to understand the context of the act. So next in the preliminary, we come to the interpretation clause. Now, what is interpretation? Interpretation or construction of law is the process by which the court seeks to ascertain the meaning of a given provision. It, the court in this case tries to understand that what did the legislature exactly wanted to provide through this particular act, and it looks into exclusively the verbal expression of the law, which words are used, how they are used, where are the commas, where is the full stop. So it has to be taken, words have to be taken in their literal sense and ordinary connotation and according to that grammatical construction. That is commas, where are the commas and where is the full stop. So there cannot be any logical interpretation to this. it can only happen if the words are unclear or the meaning is ambiguous. So next we come to the section 2, which is the interpretation clause, interpretation or the definition clause. So it begins with the words and expression used in the following senses, unless a contrary intention appears from the context. So there are certain words which are given, words like proposal, words like promise, promisor, promisee, consideration, agreement, contract, voidable contracts, void contracts. So all these words have to be understood with the respect which it is given in this particular section. If any word and any explanation is contrary, so it has to be understood in that particular context. So section 2a gives us the definition of the word proposal. So this is very important because it is the basis of the particular contract act, that we should understand what is a proposal. So that is given under section 2a. We will understand each of the definition in detail later on, but we'll just go through the definitions as they are given in the act right now. So proposal is when a person signifies to another his willingness to do or to abstain from doing anything with a view to obtaining the assent of that another to such act or abstinence. He is said to make a proposal. So there is a positive aspect which is to do, and a negative aspect which is to abstain from doing to get a assent of another. So the acceptance of another is very important to create a proposal. After that comes the word promise. So when the person to whom the proposal is made signifies his assent thereto, the proposal is said to be accepted. So a proposal when accepted becomes a promise. So a proposal which was there in section 2a becomes a promise under section 2b when it is accepted by the other person to whom it has been made. Next we come to 2c, which gives the words promisor and promisee. So promisor is nothing but the person who is making the proposal under section 2a, and it is the person accepting the proposal is the promisee. So when it is accepted under B, that person who accepts the promise becomes the promisee. Now when we come to the section 2d, it gives us the word consideration. So when at the desire of the promisor who is making the proposal, the promisee who has accepted the proposal or any other person has done or abstained from doing or does or abstains from doing or promises to do or abstain from doing something, such act or absistence or promise is called a consideration for the promise. So in any contract, any agreement, there is a very important aspect of consideration. So this section 2d gives us the definition for the consideration. After that we come to 2e, which is the definition for the word agreement. Now agreement is nothing but every promise and every set of promises forming the consideration for each other is an agreement. So there are a promise and every set of promises forming the consideration for each other are is an agreement. After that we come to 2f, which gives us the definition of reciprocal promises. So promises which form the consideration or part of the consideration for each other are called reciprocal promises. After that we come to 2g. An agreement not enforceable by law is said to be void. So agreement which is not enforceable is void, ab initio. There is, right from the beginning, it is void. Under 2H, we come to the definition of the word contract, which is very important because our act itself is Indian Contract Act. So, a agreement enforceable by law is a contract. So, from here we often get that particular conclusion that all contracts are agreements, but all agreements are not contracts, because when an agreement is not enforceable by law, it is void, and an agreement enforceable by law is a contract. Then we come to 2I, which is an agreement which is enforceable by law at the option of one or more of the parties thereto, but not at the option of the other or others, is a voidable contract. So there are two parties involved in a agreement. Now one party is willing to do it, but the other party is not willing to do it for some or the other reason, which are discussed later on. So then that agreement which is not acceptable to the other party is a voidable contract. Now, a contract which ceases to be enforceable by law becomes void when it ceases to be enforceable. So there may be some contracts that under the law, that contracts cannot be enforced. The law itself changes or something is repealed. So when a contract which ceases to be enforceable by law becomes void, then it ceases to be enforceable. So then it does not remain a contract basically. So this covers our definition under the section 2, interpretation clause. We will be understanding this each of the words and the definition in detail in subsequent videos. Thank you.